Good day to each and everyone, especially to you, sir. Now I'm going to narrate the Rule 128 to Rule 130. So, Rule 128, the General Provisions, Section 1, Rule 128, Evidence. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting in a matter of fact. So, Section 2 of these rules, Scope. The rules of evidence shall be the same in all trials, courts, and hearings, except as otherwise provided by the law of these rules. So, Section 3 of these rules, Admissibility of Evidence. Evidence is admissible when it is relevant to the issue and it is not excluded by the law of these rules. Section 4 of these rules, the relevancy and collateral matters. Evidence must have such a relation in the fact and issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it stands in any reasonable degree to establish the probability and the probability of the fact. So, Rule 129, Section 1, Judicial Notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, the law of nations, the admiralty and maritime courts of the world, and their seals, the political constitutions and history of the Philippines, the official acts of the legislative, executive, and judicial departments of the Philippines, the laws of nature, the measure of time, and the geographical division. So, Section 2 of these rules, Judicial Notice when discretionary. A court may take judicial notice of matters which are of public knowledge or are capable of unquestionable demonstration or ought to be known to judge because of their judicial function. So, Section 3 of these rules, the judicial notice when hearing necessary. During the trial, the court on its own initiative or on request of a party may announce its intention to take judicial notice of any matter and allow the parties to be heard thereon. So next is the Section 4 of Rule 129, Judicial Admission. An admission, verbal or written, made by a party in the course of proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through a palpable mistake or that no such admission was made. So next rule is the 130, Rules of Admissibility. Objective Real Evidence. Section 1 of Rule 130. Object as evidence. Object as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to examine or viewed by the court. So next rule is the Section 2 of Rule 130, the documentary evidence. Documents as evidence consist of writing or any material containing letters, words, numbers, figures, symbols, or other modes of written expressions offered as proof of their contents. So next is the Section 3 of Rule 130, Best Evidence Rule. So original document must be produced, exception. When the subject of inquiry is the contents of the document, no evidence shall be admissible other than the original document itself, except in the following cases: when the original has been lost or destroyed, when the original is in the custody or under the control of the party against whom the evidence is offered, when the original consists of numerous accounts or other documents which cannot be examined in the court without great loss of time, and the fact sought to be established from them is only the general result of the whole. And last is when the original is public record in the custody of public officer or is recorded elected public office. So, Section 4 of these rules, Rule 130, the original of the document. The original of the document is one of the contents of which are the subject of inquiry. B. When a document is in two or more copies executed at or about the same time with identical contents, all such copies are equally regarded as originals. So C. When an entry is repeated in the regular court of business, one being copied from another is subjected as the original. Next is the Section 9 of Rule 130, the parole evidence rule. Evidence of writing agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon there can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the writing agreement. Next is the Section 10 of Rule 130, Interpretation of Documents. Interpretation of writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution unless the parties intended otherwise. Section 11, Rule 130, Instrument constructed so as to give effect to all provisions. In the constructions of an instrument where there are several provisions or particulars, such as construction is, if possible, to be adopted as well give effect to all. Section 2 of this rule, Interpretation. Section 12 of this rule, Interpretation according to intention, general and particular provision. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and the particular provisions are inconsistent, the latter is paramount to the former. Section 13 of these rules, Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the position of those whose language he is to interpret. So the Section 14 of these rules, peculiar significations of terms. The terms of writing are presumed to have been used in their primary and general. So next is the Section 20 of Rule 130, the testimonial evidence, qualification of the witnesses. So witnesses, their qualification. Except as provided in the next succeeding section, all persons who can perceive and perceiving can make known their perceptions to others may be witness. 121 of Rule 130, disqualification by reasons of mental incapacity or immaturity. The following persons cannot be witness: those whose mental condition at the time of their production for examination is such that they are incapable of intelligently making known their perceptions to others. Second, the children whose mental maturity is such as to render them incapable of perceiving the facts respecting which they are examined and of relating them in truthfully. Section 22 of this Rule 130, disqualification by reasons of marriage. During their marriage, neither the husband nor the wife may testify for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. Section 23 of Rule 130, disqualification by reasons of death or insanity of adverse party. Parties assignors of parties to a case, or persons in whose behalf a case is prosecuted against an executor or the administrator or other representative of a deceased person, or against a person of unsound mind upon a claim or demand against the state of such deceased person or against such persons of unsound mind cannot testify as to any matter of fact occurring before the death of such deceased person, before such person became of unsound. Section 24 of these rules 130, disqualification by reasons of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases: the husband or the wife during or after the marriage cannot be examined without the consent of the other as to any communication received in confidence by one from others during the marriage, except in a civil case by against the other. So, Section 29 of these rules, admission by a co-partner or agent. The act or declaration of a partner or agent of the party within the scope of this partnership or agency may be given in evidence against such party after the partnership or agency is shown by evidence other than such act of declaration. So, Section 33 of Rule 130, confession. The declaration of an accused acknowledging his guilt of the offense charged or of any offenses necessarily included therein may be given to evidence against them. The next rule is Rule 131, burden of proof and presumption. Section 1 of Rule 131, burden of proof. Burden of proof is the duty of a party to present evidence on the fact and issue necessary to establish his claim or defense by the amount of evidence required by Section 2 of this Rule 131, conclusive presumption. The following are instances of conclusive presumption. First, whenever a party has by his own declaration, act, or omission intentionally and deliberately lead another to believe a particular thing true and to act upon such belief, he cannot in any litigation arising out of such declaration, act, or omission be permitted to falsify it. Second, the tenant is not permitted to deny the title of his landlord at the time of the commencement of the relation of landlord and tenant between them. Section 4 of Rule 131. No presumption of legitimacy or illegitimacy. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the